Hello.
Hello.
All right, so to make you a co-host, where do I do that?
Go down to participants, where it's
Okay,
just
make
and
co-host.
then just go on it. It should come. Yeah, exactly. Hit on the ellipses.
Okay.
And I'm going to pause. I would like to alert everyone that we are going to be recording today's session so that Baltimore Innovation Week has access to the content and we can share with you today as well as those that might have missed it. So we're going to go ahead and get started, and more people will join, I'm sure. But again, it's our honor to be here as part of Baltimore Innovation Week. My name is Lisa Friedlander, and I'm excited to introduce Anthony Millin, who is the chair of Next, and who will be talking about the legal aspects of fundraising this morning. Anthony?
Great, thank you so much. Let me share my screen. Great, are you seeing that, Lisa?
Yes.
Good, all right. Well, it's great to be here today with everybody as part of Baltimore Innovation Week. The topics that we're going to be covering today are the legal aspects of raising financing, and we're going to go in at a fairly detailed level of some of the key ideas that that people should know about as you're getting ready to enter the financing process. Just briefly about myself, my background, I've been involved in the startup ecosystem for over 20 years as a serial entrepreneur. I've co-founded several companies. I'm a venture partner in Urban Us, a seed stage venture capital fund, focusing on urban tech, and a startup attorney where I'm the founder and chair of Next, powered by Shulman Rogers. Next is an innovative new model for delivering legal services for the full life cycle of startup and emerging growth companies. We offer predictable legal fees through more than 75 fixed price packages and service bundles designed for startup and emerging growth companies. And our clients receive guidance in a very hands-on, high-touch approach from senior attorneys. And we also integrate technology platforms from NASDAQ and Carta and UShare to create a very client-centric, responsive, collaborative, transparent model of delivering legal services. And for more information on us, please feel free to visit us at www.next.law. So the first place that we're going to start in raising capital is with the term sheet. So a term sheet is usually the first document that's prepared and negotiated, and it highlights key terms for the transaction. So why do people use term sheets, and why is it good to start with term sheets? Number one, it helps you flush out or identify the key deal terms. It enables you to discover earlier in the process, before you've spent weeks with a particular investor, whether there were any deal breaker terms that could have been discovered earlier in the process. This facilitates drafting and negotiating the definitive documents. So when you're ready to draft the final documents, it's much easier and reduces the overall time and expense of a deal to have really identified and prepared the term sheet up front. And it also makes it harder for parties to change their positions later on particular terms if they've already negotiated and signed a term sheet. Term sheets are usually non-binding in terms of making the investment, but may include some binding provisions such as confidentiality. Exclusivity period sometimes shows up where an investor asks for an exclusive period after signing the term sheet to close the deal. Governing law, so what the term sheet is governed by, and also attorney's fees around the this part of the engagement. So what are some of the securities that you could show up in a term sheet when you're raising capital? So the first is there's common stock. Founders are usually issued common stock when they form the company, but for some investors, particularly a friends and family round, those may start with common stock as well. You have preferred stock. Preferred stock, which includes Series C, sometimes also referred to as AA or Series A, B, C. These are shares that investors who are investing in a priced round are usually issued preferred stock. And it includes rights and preferences that are superior to the common stock. So it gives certain rights and preferences to the preferred stockholders that sit above the common stockholders. And it also will go into a little bit more detail later in the presentation, provides protective provisions over the common stock. You also can have convertible notes, and we'll talk in a few minutes about convertible notes. Safes is something that is becoming more frequently used. And so a simple agreement for future equity. And sometimes some term sheets also include warrants. And so we're going to just touch on what a warrant is. So a convertible note, which is where we'll start, is a debt instrument with interest that usually accrues, meaning the interest accrues, you're not paying it in real time. And when you eventually convert, it converts, it gets added to the principal at the time of conversion or repaid at that point. Part of the reason people do convertible notes is it bypasses the need for an upfront agreement on current valuation. So it's very hard at the very earliest stages of a company for investors and founders to reach agreement on valuation. The founders see all of the upside potential of their company and how big and large and successful it can become. And the investors see the risks. They see the capital risk and the execution risk and the product or technology risk and the market risk. So when you're at a stage where there is just a minimum viable product, or even before the minimum viable product, or you have some customers but not sustained revenue yet, that could make it a little harder. So you use the convertible note at that point in time. And what are the key terms that show up in a convertible note? Number one, you have an interest rate. You have the term of the note, so whether it's an 18-month or a 24-month note, for example. You have the conversion terms, which dictates when it converts automatically on a voluntary basis as part of a corporate transaction or at maturity. And then the two terms that are often the most negotiated, one is the discount rate, although you're often seeing that at around 20%. And then there's the cap, and we'll talk a little bit more about the cap, which is the maximum value the investor will pay on conversion. So the idea behind the convertible note is you let the next round, or eventually a priced round of preferred stock, put the value of the company, and the investors who come in the convertible note convert at a discount, like a 20% discount to those future investors, or at the cap. And also the convertible note holders have priority to the assets of the company above the common stockholders or any other preferred stockholders that are already in the cap table. So let's just talk briefly about the cap, since it's such an important concept to understand. And you see it very often in term sheets that you're putting together with investors for a convertible note. So for example, a company that has 1 million shares of common stock, it issues a $500,000 convertible note with a 20% discount and a $5 million cap. The company is subsequently able in a priced round to raise capital in preferred stock financing at a 10 million pre-money valuation. So how does the cap work? Well, the new investors who are coming in, there's no cap or discount for the new preferred stockholder investors. And so for them, the valuation is 10 million. If there's 1 million shares outstanding, it's $10 a share. So they get 50,000 shares. For anyone who's coming in at the 20% discount, if the discount is preferable to the investor than the cap, a 20% discount would be 8 million valuation. So 20% discount off of 10, $8 a share, or that investor gets 62,500 shares. But you can see if an investor also negotiated for a cap, in this particular instance, the cap is 5 million. So even though the new preferred stockholders are coming in at 10 million, The convertible note holders will convert at 5 million cap, which is $5 a share, or they would end up with approximately 100,000 shares. And this example, we're ignoring the interest. We're just looking at the principal for purposes of the calculation. So you can see the big differences between no cap or no discount. The investor for their investment ends up with 50,000 shares, 62,500 at a 20% discount, but 100,000 shares at the cap. So very important concept to understand and to model out and to look when you're negotiating a cap. Another instrument that has become very popular for seed stage financings and pre-seed financings is a SAFE, a simple agreement for future equity. The big difference between the SAFE and the convertible notes is that there is no interest and there is no maturity date. So it's a much more simple instrument or securities, since you're not dealing with the situation of you've raised $1 million, you hit the maturity date. On a convertible note, you haven't set up automatic conversion at maturity, and now the note has to be repaid with interest, and you don't have the $1 million plus interest to repay the note. And so that created either a renegotiation with investors at that point in time, or a lot more negotiation up front as to how to address that situation. So with the SAFE, it just eliminates that. You end up with just the two core terms of the discount rate, which we spoke about, and the cap, which we spoke about. And that cap could be a pre-money cap or a post-money cap, and we'll talk in a few minutes about the difference between pre and post-money. The SAFE converts, like the convertible note, into equity when you have your next round of financing at the discount or the cap, or if you sell the company, you either can get your money back at just say 1 times the investment, or you convert at the cap and participate in the proceeds of the transaction. You're not a shareholder until the SAFE converts over into equity. And you also, like with the convertible note, have priority and can be drafted in a way to have priority over the common and the preferred shareholders to the assets of the company. And then the last thing we'll talk about from a security perspective is the warrants. So warrant is a derivative that confers rights, but not the obligation. So it gives you the right, but not the obligation to buy equity. So just say common stock at a certain price before the expiration. It's often used as an additional incentive to an investor for moving quickly. So sometimes you want to give an extra incentive to an investor for being a first mover or moving quickly. Or sometimes you want to sweeten a deal with a strategic partner, and you want to put some equity into that deal with the strategic partner. So you put in a warrant. And so the key terms of the warrant are how many shares can be purchased under the warrant. So for example, 50,000 shares. The exercise price, which is the price that the warrant, so let's just say you can buy those shares at $1 a share. The term of the warrant, so you have 5 years to buy those shares at $1 a share to exercise that warrant, and it could be a cashless exercise if that's built in. So as a warrant holder, you can wait for the shares to be worth $5 or $10 a share before, to be in the money, as it's often described, before you actually exercise the warrant. So those are the core securities. Now you're ready to negotiate with your investors. And there are 3 key areas or levers of negotiating with investors. The first one, where founders often spend most of their time and attention, is on the valuation of the company. And this drives the percent of the company you're selling in the financing. So if you're negotiating a priced round, it's the valuation in that priced round. We also talked before about caps in convertible notes and safes. Also, if you're negotiating that. But in a priced round, what we're talking about is the pre-money or post-money valuation of the company. Now, investors will look at valuation, but they also spend a lot of time looking at rights and preferences and investor protections. And so it's very important as a founder to understand these other elements of the negotiation, because over the long term, if you're building a very big successful company, a few equity points difference. So if you own 20, you're selling 20% versus 18% or 16%, may not really make a big difference down the road in a successful company. But these rights and preferences, investor protections, can have a big impact on the way things go forward in terms of building and operating and growing your business. So investor rights and preferences are preferences with respect to distributions of profit or distributions upon a liquidity event. It also drives rights, for example, like rights to participate in new issuances of securities. And investor protections, or the control provisions, drive the level of control that the investor, who usually owns a minority interest in the company, so maybe just say 15 or 20 or 25%, giving them certain veto rights or certain control over major actions of the company through their shareholder status or through a board seat that they hold on the board. So we'll go into these now. Again, remember that it's very important to be educated and to understand the different rights and preferences and investor protections that show up in a negotiation. In terms of the value of the company, there are two key concepts to understand. One is is the valuation pre-money or post-money, and calculating the share price from that valuation on a fully diluted basis, which all show up in term sheets. So the pre-money valuation is the valuation of the company that does not include the new money, the new cash that is being raised. And the post-money valuation is the valuation of the company, including the new cash that has just been raised. And this is really important because it changes the level of the company that an investor is receiving for the same dollar investment. So for example, if an entrepreneur is raising $500,000 and the investor and the entrepreneur agree on a valuation of $2 million, if that $2 million is pre-money, then that business is worth $2.5 million once you've raised the $500,000. And the investor who's investing $500,000 is receiving $500,000 on the $2.5 million post-money valuation, post-money, after the money's come in. And so they're getting 20% of the company. So the business was worth $2 million before, you put in $500,000, it's now worth $2.5 million. The investor owns $500,000 out of $2.5 million, or 20%. If it's on a post-money valuation, and that's what the investor is negotiated, then the business is worth $2 million after the $500,000 is invested, which means it was worth $1.5 million before. And so the investor is investing $500,000 of $2 million after their money is in, or 25%. So you can see the same $500,000, but the investor is either getting 20% or 25%, 20% if it's pre-money, 25% if it's post-money. And so as an entrepreneur, it could be pre or post, but you have to understand when you're negotiating with an investor and you're agreeing on a valuation, which one it is. The next concept is just the fully diluted basis. So when you calculate a share price, you're dividing the value of the company by the number of shares. That gives you the share price. But what is included in that denominator? Is it all the issued and outstanding shares only? Is it stock options reserved in an equity incentive plan that have not been granted or exercised? Does it include warrants that have been issued and not exercised? All of that is going to change the share price. If a share term sheet says it's been calculated on a fully diluted basis, they're including all of those, A, B, and C in this example. And investors will almost always require a share price calculation on a fully diluted basis, so they're not diluted by warrants or stock options in the plan. And in fact, if they don't think there's enough shares in the plan, they may even ask you to increase the plan immediately before closing and put those increased shares in the fully diluted calculation, again, to make sure they're not diluted by it. So as an example, if you have 2 million shares outstanding, 500,000 shares in an option plan, in this example, they haven't been granted or they've been granted and not exercised, and someone's investing $500,000 at a $2 million valuation, pre-money valuation, the share price, if you're just looking at the 2 million shares outstanding, would be $1 a share, 2 million divided by 2 million. If you invest 500,000 at $1 a share, you're getting, as an investor, 500,000 shares. Same pre-money valuation of 2 million, same $500,000 investment, but if it's been calculated on a fully diluted basis, you include the 500,000 options in the plan. So it's 2 million divided by 2.5 million, or 80 cents a share. And so for that same investment at the same pre-money valuation, the investors end up with 625,000 shares. So you can see it makes a difference if it's been calculated. Again, as an entrepreneur, assume that it's going to be on a fully diluted basis. And when you're setting your valuation and you're modeling out what that impact is going to be of selling shares, model it on a fully diluted basis. The next thing we're going to talk about are rights and preferences. And in the long run, these are often more important than a small difference in valuation. And these include terms that are going to show up like liquidation preference, participating versus non-participating, preemptive rights, information rights, drag-along rights, anti-dilution rights, and then a range of others that we won't cover today, like dividends, rights of first refusal and redemption, registration, board seats. So you can see all of these different rights are what investors are focusing on, and it's really important for you to understand what these mean and to be prepared and ready with your legal counsel to negotiate these. The liquidation preference is a mechanism by which investor seeks to recoup its original investment or a multiple of that investment, plus any declared and unpaid dividends before any distributions to the common stockholders, which includes the founders. And so an example of a one-time liquidation preference means 1 million. If somebody invests $1 million with a one-time liquidation preference, the first million goes to the investor before the common shareholders get their first dollar. If somebody negotiates for a 2x liquidation preference, they're getting $2 million to the investor before the first dollar goes to the common stockholders. So important to look out for liquidation preferences and to understand what it means if you suddenly see a liquidation preference that's more than 1x. The next concept we're going to talk about, which is really important to understand, is participating versus non-participating liquidation preference. And the way I've illustrated this today is through, imagine there are two doors. In door number one, when the investor walks through that door, they get their liquidation preference that we just spoke about. They get their money back, 1x liquidation preference. In door number two, the investor, when they walk through that door, they converting or deem to convert their preferred stock to common stock and share in the proceeds of the sale based on their ownership. So if they own 20% of the equity, they get 20% of the proceeds. And in a non-participating preferred structure, the investor is either getting door number one or door number two. They can either get their $1 million back, or they can convert and get 20% of the proceeds of the sale of the company. But in participating preferred, the investor is telling you and negotiating to get both. They're saying, first, I want to walk through door number one and get my 1x money back, or $1 million. Then I want to convert to 20% equity. And then I want to walk through door number two with the equity holders and get 20% of the proceeds. So really important to see if what is being negotiated for is participating versus non-participating preferred. Preemptive rights protect investors against dilution from future financings. So if an investor owns 20% of the company and they've negotiated for preemptive rights, and you're raising another round of funding, they have the right to take 20% of that next round of funding or future rounds of funding that they have preemptive rights in to maintain their 20% ownership position. Sometimes if a new investor coming into a future round wants to take more of the round, then like you've already given preemptive rights for 30% of the next round, and an investor wants to do 80%, the new investor wants to do 80, and you have promised under preemptive rights 30% to prior investors, you may have to get waivers from some of your preemptive right holders and renegotiate with them. So it's important to understand, and this is sometimes a right for that reason that gets reserved instead of to every investor who comes in, only to what are defined as major investors. So an example could be an investor who invested at least $250,000. Information rights are the right to financial information such as income statements, balance sheets, cash flow statements. These could be audited or unaudited. For earlier stage companies, it's typically unaudited. And it's really important to share information with your investors and for them to be well informed as to the financial status of the company. You often hit bumps in the road, and you never want to surprise investors right before you're running out of money. You want them to know where you are. So information rights, although it's a right being negotiated from an investor's perspective, it's important from the entrepreneur. What you tend to negotiate, though, is how frequent. So is this annual? Is this quarterly? Is this monthly? Is it just financial statements? Is it key financial metrics and budgets? So you're weighing the benefits to the investor versus the burden on management to produce. And again, sometimes you may limit the more frequent information rights to major investors, which we spoke about, larger investors, but that's information rights. Drag along rights is when just say the board and a certain number of investors or class of investors vote to sell the company, everyone gets dragged along. So everyone signs up that if those trigger events happen, everybody has to sell. So you're not in a position where one investor who owns a small portion of the company is holding up the sale of the company by refusing to sell. So this drag along right's a really important right as well. Anti-dilution protection protects investors not just from dilution. You know, people get diluted whenever you raise rounds of funding that own less of the company, but if the value of the business keeps going up, their overall value of the investment grows even though they own a smaller percent. In this anti-dilution protection, this is more what happens if you have a down round, and it ranges all the way from a full ratchet where even if you sell a very small number of shares at a lower price, if investors have this anti-dilution protection, their whole investment gets repriced at this lower price when you eventually convert to common stock. A broad-based weighted average, for instance, on the other end is most favorable to entrepreneurs and most commonly shows up these days in term sheets, takes into account not just the fact that it was a lower price, but also how many shares were issued in that lower price based on how many shares are outstanding on a fully diluted basis. So again, you want to see whether it's what shows up in the term sheet and understand the difference between a full ratchet or a broad-based weighted average. You know, one is very hard on the entrepreneur, one is more fair to the entrepreneur. And then we go into protective provisions. And in the protective provisions, these are provisions that investors put into place to give them more control when they have maybe one seat on a 5-seat board or 15% of the company, but want to exert more control over the company. And so the way it works is investors will, as just say a class of Series A preferred, you have to get approval of the majority of the Series A preferred investors or the Series A board member to make certain decisions as the founders of the company or as the majority holders of the company's shares or controlling the board. You still have to get approval of that one board member or the majority of that Series A class to amend the certificate and the bylaws to repurchase or redeem equity. People could negotiate, investors could negotiate for the same approval rights to materially change the nature of the business or the size of the board. The big one is around issuing new equity. Do you have to, anytime you issue new equity, do you have to get approval from the prior investors or their board member? Or in every instance, or just instances where you have new securities that are below the last round or equal to the last round, or only when it's superior, or superior in ranking and preferences to the last round. So those are where you end up negotiating around hiring and firing employees, taking on a certain amount of debt above a certain number, or the sale of the company. So if the founders want to sell the company, or a majority want to sell the company, do you have to get approval from that group of shareholders as well? And so that's a negotiation that you may have around the sale of the company, whether it's always there, or whether if the investors get a certain level of return, that right doesn't exist. But those are negotiations that will be happening. And then liquidating, dissolving, and winding up the company. So we have about 10 minutes left, although we started a little bit later. The session before ran a little bit later, so maybe we, but what we wanted to do is to just see if there is any time or any questions that we have left. So Lisa, do you want to see if anyone has any questions, or if anything's been posted?
Yes, I have not seen anything to the chat. So if you have a question, feel free to unmute yourself. And then as we're going, other folks can add to the chat. I know there's a lot of great information that's just been downloaded. So feel free to spend the rest of the time asking some questions.
This is Gary McDaniel. A question, I gotta put my video on so you can see me. Here we go.
Thanks, Gary.
How are you all today? Thank you. A nice presentation. I guess one of the things that I wonder about is in convertible debt. To me, convertible debt is issued when you don't know what the valuation is going to be, so you kick the can down the road for a valuation in the future. And to me, a cap kind of undermines that, right? You're sort of putting a presumed valuation on the company with a cap. And I like having a discount because they're taking a risk on a company. They don't know what the valuation is going to be, so we're going to negotiate for a discount. But putting in a cap to me seems counter to the concept of convertible debt.
Yes, so there is a balance and in the negotiation that goes on whether to include the cap or not include the cap. And part of the reason the investors will push for a cap is if you have a very big jump in valuation, they want some protection since it's that growth is happening on their investment. They want to make sure that the 20% discount may just not seem enough. So sometimes what you end up when you negotiate a cap is you end up with a cap that's higher than the value would be today. So you put a cap in, but the cap ends up being much higher than what your value would be today if you did a priced round. So sometimes you'll try to negotiate without a cap. And if you need a cap, that value should be above what the value might be today on the business.
That makes sense. I appreciate that. Thank you.
Sure.
Thanks, Gary. Anthony, we have a question from Patty regarding valuation. Who should be the first one to sort of initiate or state a valuation first? Should it be the founder or should it be the investor?
Sometimes an investor will often try to put that on the founder to get a sense of what value they're looking for. I think that as a founder, you shouldn't, if you are kind of forced to put the value out first, you can be, people, if they're interested in your business, can always come back if they don't agree with your valuation and try to negotiate with you on that valuation. So you shouldn't undersell yourself on that valuation. There are times as you get into later rounds where you get a full term sheet from a venture investor, and that term sheet will include all of the terms, including the valuation. In the earlier stage seed financings with angel investors and other early stage investors, sometimes you would look for the term sheet to come from the founder to the angel investor. So it also depends a little bit on stage.
Great. Thank you, Anthony. Next up, we have a question from Tony. How long should a company plan to complete the process of a seed fundraising?
I typically would say that you want to give yourself at least 6 months. They can happen faster. I've also seen rounds take longer than that. But I think in terms of cash flow and planning, you want to give yourself like 4 to 6 months to make sure that you have enough runway to do a round. Again, it could always be a little bit more or a little bit less, but and then once you've raised money between rounds, you'll often want to make sure you have at least a year runway, and then about halfway before that, start raising the next round.
Great. Next question. After 2020, and as companies are reassessing an office and city presence, how is the investor-startup relationship changing? That's
in terms of not having physical offices?
Chris,
sorry, I didn't.
Feel free to unmute and clarify your question if you'd like. Yes. In terms of not having office space.
Yeah, I think a lot of teams now are becoming distributed teams, and we're seeing a lot of startup companies being able to successfully operate in a distributed environment. I think that there were many teams that were distributed teams before, so maybe there was a small hub of people, and then the rest of the team was spread around. And I think that that's going to I think COVID and everyone operating in a distributed fashion, I think is going to impact that. But I think that you are seeing more distributed teams showing up. We're seeing a lot of companies that we're working with going out to raise capital with distributed teams. I think as you get bigger, it may, for purposes of company culture and other types of things, become important to have some basis of a hub that people can be part of. But I do think that in these earlier stages, we're seeing a lot of distributed teams.
Eddie, that was the last question I have in the chat. We have a few minutes left.
Okay, if there aren't any more, there are a couple of other things that we can cover that I'm happy to go through quickly.
That would be great.
Okay. So a couple of other things that are important in raising capital. One is due diligence. So when you once you enter the due diligence phase, and in every deal there's a due diligence phase that's broken down into business due diligence, financial due diligence, and legal due diligence. And on the legal due diligence side, you're looking at corporate structure, so all of the formation related documentation that was put into place, and make sure it was all correctly done. You're looking at the cap table and all of anything that feeds into the cap table, making sure everything was properly issued and authorized and reflected. There's nothing out there where people were promised shares that aren't reflected in the cap table. The team, you're going to be looking to see everyone signed restrictive stock purchase agreements and PIIAA agreements. And if they're employees or consultants, they've signed agreements, material agreements with vendors or customers, intellectual property like patents and trademarks and other IP, and if there's any regulatory or litigation risk. So really spend time up front prepared. The worst thing from an investor at this due diligence phase is you're excited about a company, you've signed off on a term sheet, you go into due diligence and the company's not prepared. There are a lot of things done early on that were not done correctly, that haven't been corrected, or people disappear for 2 weeks or 3 weeks to get themselves organized. You know this is coming and you want to be ready for it. It gives a lot of confidence to the investors when a company is organized and ready for due diligence, and it raises red flags when you're not.
Anthony, real quick to interrupt before you move on, we do have an additional question. How do we allocate equity to initial friends and family? Any general strategies?
Yeah, I mean, in terms of friends and family, typically what happens is people, if they're not coming in as founders of the company, they're getting their shares through investing, and it could be at a very low price early on in the company. Or you could, for friends and family, if you don't want to be negotiating a valuation with people who are friends and family, you can bring them in through a safe, for instance, or a convertible note, where you let the later investors set the price and they can come in at a discount to that. You do always want to look, regardless of who the investor is, at accredited investor status anytime you're issuing a security.
Great.
Great. Just two more important points. The first one is, when you're preparing your final documents, these are the kinds of documents you would prepare. If it's a Series seed financing, you're going to be putting together a stock purchase agreement, a stockholder agreement, and you're going to amend and restate your certificate. When you get into Series A, it's the same. You're going to have a stock purchase and an amended and restated certificate. The stockholder agreement is often broken out into an investor rights agreement, a right of first refusal, and a voting agreement are your main core documents. In a convertible note, you're negotiating a note purchase agreement and a convertible, and then the actual promissory note. And you can see a safe, which is kind of the more simple documentation than some of these other types of financings, and part of its popularity is just the safe. And then the final area to just be aware of when you're out raising capital, and that is, anytime you raise money, it's regulated by the Securities Act of 1933. And under Section 5, all issuers must register non-exempt securities. So if you don't have an exemption, you have to register, which is very time-consuming and expensive. And most instances, when you're raising money, you are going through an exemption. You have Section 4A2, which basically says Section 5 doesn't apply to transactions by an issuer not involving any public offering, and there are two safe harbors for that. And people have maybe heard other entrepreneurs or seen it yourself or read about Reg D or Regulation D, which sets out these two safe harbors under Rule 506. 506B, where you cannot broadly solicit or generally advertise, and that is kind of the most frequently used exemption of 506 under Reg D. And 506C, where you can broadly solicit and generally advertise, but you do need third-party accredited investor verification to make sure someone's verified as an accredited investor. And you have to you would file a Form D with the SEC, and then look to see if there's any other security filings that may be required at a state level, or if there are self-executing exemptions, or there is some action that needs to be taken. So that's kind of the last part of raising capital, is just to remember you always have to look at the security side of it as well. And that's it.
Fantastic. Well, we hope everybody found it useful and learned something new, or at least reiterated things that you may have known before. We will absolutely circulate this deck. I saw some of the requests in the chat. I will get that from Anthony and follow up with everyone, including the recording. So I hope you have a great rest of the day for Baltimore Innovation Week.
And then, Lisa, I just want to say, remind people, if they want more information, they can go to next.law. And my email is on the slide. If people have questions they didn't get to ask today or thought about after today's presentation, please feel free to reach out to me at amillin@shulmanrogers.com. And like Lisa said, we really appreciate everyone joining us today.
Terrific. And to answer one last question, I have the contact information that you all registered for today's event with. That's the email I will use. If you would like me to use a different email, reach out at info@next.law. Thank you so much and have a great rest of the day.
Great. Thank you.
Thanks, everybody.